And I will first recognize Mr. Mix for 5 minutes.
Thank you, Congressman. It's a privilege to be with you today to talk about H.R. 1200. First of all, I want to call out Congressman Joe Wilson for adhering to the Paper Reduction Act by introducing a bill that's simply one page.
How about that?
As Congressman Good said, this bill doesn't add a single word to federal law. It simply repeals those provisions in the 1935 National Labor Relations Act, upheld by the United States Supreme Court in 1937, of the provisions that authorize compulsory forced unionism. Nothing in this law, as President Eisenhower would say, you'd be a fool to get involved to get in the way of union organizing. Nothing in this bill would damage or stop any unionizing or organizing at all. The fact of the matter is the right to work issue is a battle between workers and union officials. There are no other parties to this battle because union officials believe that if workers are given the choice to decide whether or not to financially support a labor union, they might leave. And that's the problem with the issue of forced unionism. I want to bring to your attention, you mentioned the Ford contract that just came up, but I want to talk with you about the language on page 2 of that contract, which is the most important element of the contract according to the United Auto Workers. Here's what it says. Employees covered by this agreement at this time become effective and who are members of the union at the time shall be required as a condition of continued employment to continue membership in the union for the duration of this agreement. Employees covered by this agreement who are not members of the union at the time of this agreement becomes effective shall be required as a condition of continued employment to become members of the union on or within 10 days of the effectiveness date of this contract. As an individual employee reading that and a union official coming to you say you have to pay union dues as a condition of getting or keeping a job, you have to be a member of the union, what would an ordinary person say about that language? It basically reeks of compulsion. And you know, when we talk about the National Labor Relations Act, Section 7 rights talk about the employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activity for the purpose of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all such activity. If Congress would have put a period there, we wouldn't be having this discussion today, because the compulsion would not be there and voluntary unions and the right to refrain would be there. But it went on and said, except to the extent that the right may be affected by an agreement requiring membership in a labor organization as a condition of employment is authorized by Section 158A3 of this title. That's where the compulsion comes from. That's what right to work is all about. There is no block on union organizing. That right is protected under federal law, has been, will be, and should be. In fact, the NLRB puts out a 21 may nots by employers as it relates to what they can or cannot do when there's a union organization drive. I would ask that this be included in the record if we can do that, Congressman Good.
Without objection, yes.
Yeah, and as well as the union security clause from the UAW contract. I'd like to have that in the record as well.
Without objection.
Here's a statement from the bricklayers and allied craftsmen's workers about union security, which is the clause that's the first clause negotiated in a contract. Here's what it says. Union security is the primary objective of most unions. It involves compulsory membership as a condition of employment. This area of collective bargaining can be the most controversial yet necessary requirement to establish and maintain stability within the union structure. The objectives of this clause are to protect against workers leaving and rival unions raiding the union. That's the importance of union security. What our bill does is simply go into the National Labor Relations Act and says the bias in favor of compulsion in federal law should be removed. The bias should be in favor of voluntary unionism. Doesn't do anything to stop the right to associate. Doesn't do anything to stop a worker from joining or organizing a worker. Doesn't do anything from allowing a worker to give their entire paycheck to a labor union if they choose to do so. And Lord knows, based on the ranking member statement, they ought to be interested in joining a union. And they should be, because unions can maybe improve their life. But we shouldn't be imposing forced unionism on anyone here. And you'll hear stories about folks that disagreed with what the union did. We have lots of stories. At the Legal Defense Foundation, we've represented literally tens of thousands of employees who have objections, not to unions per se, but to compulsory unionism and the use of their money for ideological and other causes they may disagree with. The idea of compulsion is wrong. It's wrong anywhere. We, as citizens of our government, give you the right to use force. The government, we give that in a limited way, but we shouldn't give it to any private organization. And labor unions are private organizations, and if they're really good at what they do, according to the ranking member, why wouldn't workers want to join them? Why wouldn't they do that voluntarily? Unions don't deserve compulsion. They should operate just like any other private organization. If they're interested in adherence to their cause, then they should give up their compulsion and sell a product that workers want. Thank you.